Right, back live tonight, you're in Focus, and thanks for staying on. In an effort to bring those accused of state capture to book, Parliament has published the National Prosecuting Authority Amendment Bill for public comment. Now, over the next 2 weeks, up until the 6th of October, I believe it's the closing date, it is calling for recommendations from the public, or at least comments from the public as far as the amendment bills are concerned. This, of course, comes from the recommendation from the chair of the State Capture Commission, Chief Justice Raymond Zondo, who handed a report to President Cyril Ramaphosa. Deputy Minister of Justice and Constitutional Development, Deputy Minister Jeffery, joins us now for more on that. DM, good to have you, and thank you very much for coming on this evening to explain a little bit more on the work that this department is doing. So, if we were to take it from that introduction, I mean, it's high level, but if we are going in a little bit deeper, there are three things possibly that could have come up from the State Capture Commission. One, put in place or establish a permanent entity called the Investigating Directorate that is going to investigate corruption. Two, ensure there's a degree of transparency in how the head of that institution is appointed. And then three, strengthen the capacity of the NPA, if we summarize them. Why would you have chosen, out of those three, to deal with the top one of establishing a permanent entity called the Investigating Directorate?
Well, it's because the existing Investigating Directorate is the body that is prosecuting or trying to prosecute corruption cases, high-profile corruption cases. And what had happened was that in terms of the National Prosecuting Authority Act, there is provision for the President to establish by proclamation an investigating directorate into particular kinds of cases. And the President did that in 2019 and established an investigating directorate to look specifically at issues of corruption. However, that investigating directorate can be disestablished by another presidential proclamation. And it is also, while it can investigate, it's dependent currently on having investigators seconded to it, mainly by the police. So the intention of this bill is to create a statutory body. Therefore, it can only be repealed by Parliament, and to specifically provide for this investigating directorate to employ its own investigators. The issue of the appointment, well, my understanding is it was the appointment of the National Director of Public Prosecutions, that should be in a more transparent manner.
Yeah.
There was originally a provision relating to that in this bill. There are some legal difficulties in terms of that provision is in the Constitution, that the President appoints the National Director. When President Ramaphosa appointed this National Director of Public Prosecutions, Shamila Batoy, he did follow a transparent process. There are just some issues as to whether legislation can restrict the powers of the President in the Constitution, and whether those provisions would need to be made in the Constitution rather than in ordinary law.
Yeah. But I'm sure, but you know that the debate around some of the opposition parties is that even though you are saying that the President followed a rather transparent process, they are still not particularly sure around the independence of the NPA, and that's where the discomfort is coming from, and hence they would have wanted something like, I think, what they call an anti-corruption commission, something similar to a Chapter 9 institution like the South African Human Rights Commission that would be completely independent of the executive to investigate corruption.
Yeah, that is one of the issues, and that is something that is still on the table. The President last year, in August, I think it was, appointed a National Anti-Corruption Council, and they are busy making recommendations to government on things like the best institutional arrangements to deal with corruption. The problem with a Chapter 9 is that which is what is being punted, is that it's not something that can be achieved overnight. So the urgent step and the next step, the immediate step, is to appoint or to establish the investigating directorate as a statutory body and to give it the powers to appoint its own investigators. Yeah. There's some debate over, is that the best arrangement? I've seen, the Constitution provides that the body that prosecutes in South Africa is the NPA. So giving that power to anyone else would require a constitutional amendment. There's a whole lot of issues. So those are issues that we can debate, or they need to be quite thoroughly researched, quite thoroughly considered. There's no international best practice that everybody accepts for dealing with corruption. But in the interim, well, not even so much in the interim, but as the next step, this investigating directorate needs to be established as a statutory body.
So are you saying it would be too simplistic to say, those who are saying, well, you are making us go through this whole entire process just in order for the NPA to be able to take care of some HR issues. And essentially it's an entity so that it's able to hire its own people, put together terms of service and so on, and remuneration and so on and so forth. Surely there could be an easier way of doing that than having to go through this, what you are quoted as saying, a stopgap measure.
Yeah, stopgap was probably not the correct word to use. What I was more saying is this is something that needs to be done immediately now, as we speak, because it will make a difference. We can then debate the longer term arrangements or other arrangements for dealing with corruption, because those will take time. Those are not things that one can resolve overnight. They will take time, a lot of deliberations, constitutional amendments probably, so that's a longer issue. But the issue now is to establish this body as a permanent structure in legislation and to give it the power to employ its own investigators. The employment of investigators is not a human resources issue. Traditionally before the police do the investigations and the prosecutors then take the file, the docket from the police and give instructions about more work that needs to be done. This is going to be combining them in one body, as it was to some extent with the Scorpions. But with the Scorpions, the police members, although they were employed by that directorate, they still reported to the police. In this case, with this investigating directorate, they will report to the NPA, to the prosecutors, or to the head of this unit. And those investigators are quite crucial in being able to get the evidence to have a successful prosecution.
So let's talk about some of the other issues that are being raised, and maybe you will be able to shed more light for me, because I don't particularly understand the processes. But in terms of process, there are some who are saying, in fact, I think it's Advocate Paul Hoffman who's saying this particular bill lacks the necessary certification of the chief state law advisor, so it's unlikely to go anywhere.
Well, I don't know where Advocate Hoffman got that from. Because this bill was certified by the state law advisors before it was introduced into Parliament. So somebody fed him that story, and unfortunately, without checking on it, he ran with it as a fact. And it's not a fact, it's incorrect. The bill was certified.
Yeah. And so what does it mean when the minister says it's subject to a technical amendment for other ad hoc investigative directorates in the future?
Well, I'm not sure what you mean by that.
They're saying that the minister says he placed the bill at the National Assembly for it to of course go ahead, but it is subject to a technical amendment for other ad hoc investigative directorates in the future.
Well, again, I'm not sure the context of that. One of the later provisions in the bill before it was introduced, or when it was finally approved by Cabinet, was to keep the section in the bill. Originally, this was going to replace the powers of the President to appoint investigating directorates by proclamation. The bill establishes a permanent investigating directorate dealing with corruption, The provision that has been kept, and this may be what was being referred to, because it was a late approval by Cabinet, there's still then provision for the President by proclamation to appoint other investigating directorates on particular issues, which would then be operating as the current investigating directorate is operating. So there may be an issue of the need to appoint a specific directorate to deal with taxi violence or with illegal mining, and that can still happen. There can be more than one investigating directorate, but this one is specifically to deal with corruption.
All right. The other issue that's being raised is the one that you've just spoken about, saying there's work that the NACAC is currently doing, and it is going to be representing or presenting its report at least before the elections next year. There's a call to say, why delay? Why can't they present that report without delay? What is the holdup? They were appointed, about a year ago?
No, well, they were appointed, a year ago. I think it was in August. The issue there, well, that's something you'd need to put to them. But what I can imagine the issue being is that these issues are complicated. For example, I've seen one proposal from, I think it was from the DA. They haven't produced any bills as yet, although they said they would 2 years ago. But their proposal, from what I understand from their media statements, is they want a Chapter 9 type commission headed by a retired judge. I'm not sure if that will be constitutional in the light of the Willem Heath judgment on the SIU, where he was a judge and he was heading the SIU. A retired judge is still a judge. But their proposal was that they would investigate and then hand over matters to the NPA to prosecute. And then if the NPA didn't prosecute, they could prosecute it themselves. Now, again, I don't know how that would practically work. You either have the NPA prosecuting or you don't. But what I'm really trying to say is that these issues are quite complicated. Yeah. There is no international best practice for this. A lot of countries employ different mechanisms. It takes time. So personally, I can see why the Anti-Corruption Advisory Council is not able to rush the issue. You rush this issue, you set up an institution, and then things have not been thought through properly, and it doesn't work. Also, just to say with Chapter 9s is we've had experience of one Chapter 9 at least, which had problems in the way it was working. So a Chapter 9 institution in terms of the Constitution is not the panacea for all kinds of problems. They can also run into problems themselves.
So I hear you saying there's a call now for the public, of course, to comment, which is a very key part of the process of making laws in the country, where public consultation is actually done. Now, from a member of the public, but also in this case, member of the media, I read some of the parties, for example, saying that there must be a binding STIRS criteria must be implemented. I ask myself, what does that mean? And is that something that would be significant in terms of this amendment?
Well, that relates to the independence and the issues of independence of this body. Some of the proponents, and it comes from the Glenister case, which was when Mr. Glenister challenged the repeal of the legislation on the scorpions, which was in the NPA Act, and the passing of legislation in the Police Act to create the hawks. But the court didn't find that there had to be a Chapter 9 completely independent of government. It said that the anti-corruption body could be within the National Prosecuting Authority, it could be within the police, or it could be a standalone structure. So I think there's been a bit of distortion going on around what that judgment actually said. But the idea is to have a body that is accountable to the National Director. The National Director is independent. The Minister in the Constitution has, I think, final oversight, but does not interfere with prosecutorial decisions as to who should be prosecuted and who shouldn't be. So that's a bit of a smokescreen, I think, as well. So this is a independent body that will prosecute but be able to investigate at the same time.
So are you saying then, Deputy Minister, it is likely that those finer issues, even issues maybe that could be coming up from the NACEC report, are only going to be dealt with by the next administration?
Well, it depends, obviously, when the report comes out. There has been some talk about February. It also depends on when the elections are. But as far as legislative changes, amendments to the Constitution or to other pieces of legislation, that will be in the next Parliament. Because once their report comes out, the public will also need to see that report, need to make input. There will need to be debates. Those all might take time, but they are important to arrive at the best solution for South Africa.
Yeah. I see also added amongst the four things which we've already spoken about: provide for the establishment of the investigative directorate, provide for the appointment of investigators, provide for security screening of investigators, and provide for remuneration and conditions of service. But there's one other thing that's been added around this amendment bill, and that is the interception of communication provisions. What exactly are you looking to get there?
Well, that basically just gives this directorate the power to apply for interception orders in terms of the Regulation of Interception of Communication Act, and they do that to a designated judge who is appointed to issue such orders. So there is that element. The issue that you haven't spoken about is there's also provision in the bill that if there are complaints about the
absolutely, yes, you're right. I did pick that one up as well. Yeah. So if one has a complaint about the conduct of the investigators, you say?
Yes, then you can, and there's a similar provision in the legislation for the Hawks, and there's provision in this legislation for a judge, probably a retired judge, to be able to investigate those complaints. So again, the investigators won't have complete freedom to do whatever they want. If they do something wrong, then that would have to be taken up with the judge who's appointed to investigate.
And what's going to be then the process? I mean, is it the comments are going to be sent in writing? We saw with other bills where there was a roadshow of various provinces where even the people without maybe the connections and the technology were able to have input.
Well, that's up to Parliament and the Portfolio Committee where the bill is at the moment. Usually the process that they follow is that they've advertised for public comment, written comment, which is what you've spoken about earlier, the deadline being the 6th of October. Then they will approach people who made comment to find out if they want to make oral submissions and have those hearings. And then they would consider the bill and the submissions made. Whether they broaden it or not is something that they would need to decide on. Usually that happens if it affects particular communities, whereas in this case, this is an amendment that is more at a national level. Right. But that would be up to the Portfolio Committee to decide what they do.
Deputy Minister, I appreciate your time. Thank you very much for coming on. Deputy Minister of Justice and Constitutional Development there, John Jeffery.